parts. One about what is currently happening in India, two, what's happening in the world, in various parts of the world, and how those countries are dealing with the legal problems during this COVID-19 period. And the last would be dealing with various judgments which most of you who are lawyers would be familiar with on quashing and on grant of bail, and perhaps touching slightly on writs of habeas corpus, which can be invoked even during times of emergency. Even though we may say this is not an emergency, but we are in an emergency-like situation. So I'll start by quoting a judgment of the Supreme Court, which I use very often and which I believe expounds the principles of liberty and of the rule of law in India very aptly. It's a judgment called Dataram Singh of 2018 Supreme Court. It's Sumit, first slide.
Yeah.
A fundamental postulate of criminal jurisprudence is the presumption of innocence, meaning thereby that a person is believed to be innocent unless found guilty. Yet another important facet of our criminal jurisprudence is that grant of bail is the general rule and putting a person in jail or in prison an exception. So bail, not jail. Now, unfortunately, some of these basic principles have been lost sight of in recent times in India. And this is particularly so in the case of under trials. This is so very important because not only a person who is convicted, but an under trial who is presumed to be innocent needs even greater protection. Now, what is an interim order? Since this is about emergent orders and interim orders, first let me take you to what is an interim order. An interim order would stay proceedings, and an interim order may grant exemption, an interim order would stay coercive steps, it may stay initiation or proclaimed offender proceedings under 82, 83. So there are several interim orders in criminal law. The issue here is, as described, an act of the court should prejudice no one. Now this is not an act of court, but it's an act of the criminal justice system, and that's equally important. So steps in adjudication in the criminal justice system should not prejudice anyone, particularly if we go by the fundamentals of criminal law that a person is presumed to be innocent. What is the role of the judiciary and what is the role of the legal fraternity during this lockdown? There are two duties which need to be balanced. One is the duty of the police to maintain law and order. The other is the rule of law, which has to be preserved by the courts. So the entire criminal justice system, which includes the judiciary, the courts, the lawyers, the police, the investigative agency, all of them have to ensure that the rule of law is upheld. Now, this pandemic is potentially a death sentence for many prison inmates, and we look at various courts and how India has dealt with it, and thereafter how various courts in various countries have dealt with it. Many Indian prisons, as we all know, burst at the seams. It seems that the Bombay jail has some over 3,000 people locked in it, whereas their capacity is 1,000. Delhi also has been scrambling that thousands of inmates who are should be released on parole, furlough, or bail, as this in order to avoid the catching of this epidemic. The Supreme Court has in fact come on very quickly. There were various orders. There was an order on March 13, then there was an order on March 16th, then there was an order on March 23rd, then on 7th April, and again on 14th April. Mr. Dushyant Dave has been appointed as amicus curiae, and the Supreme Court has said that prisoners convicted of or charged with offences involving jail terms of 7 years or less must be considered for parole or interim bail. Now, Dr. K.K. Agarwal, who is president of the Heart Care Foundation, has in fact said that this is, not in his words, my words, is a potential time bomb. Delhi's Tihar prison complex, Asia's largest, has urged the government to release 1,500 convicts on parole or furlough and around the same number of under trials, not hardened or dangerous ones, but on interim bail to ease congestion. Bring it there so that I can read it. The Delhi government has issued a notification introducing emergency parole of 2 months. Now this is extremely laudatory, and Sandeep Goyal, the Director General of Prisons, has said, we have started precautionary steps against possible infection of coronavirus. We have made isolation wards in each jail for any inmate showing any like symptoms. Medical screenings of new inmates is being done, and they are being kept in separate barracks for at least 3 days. Family mulaqat and all court productions have been stopped. Let's pause here. Should a inmate not be entitled to family mulaqat? Should an inmate not be entitled to have meeting his counsel for ongoing proceedings? Now these are some of the fallouts of social distancing and legal distancing because of the COVID-19. Now, as far as delivery of FIRs is concerned, the police are going to the houses and giving copies of the FIR. It would be wise if the police, not only Delhi, but all over India, would actually refrain from arrests unless the case was a serious case of the nature that cannot brook delay. It would be laudatory that no fresh summons are issued. It would be appreciated that no fresh 82 and 83 proceedings are initiated. Anti-CAA protests, as you know, that in January, February, there were anti-CAA protesters. FIRs have been registered. 2 of them have been arrested in the first week of April. And people who were participating and protesting against the Citizen Amendment Act. The question is this something which should be done at this stage, or should it not wait till this emergency period, this pandemic, becomes lesser? The next slide would show you that the police are, even in cases where people are violating because of their fear and apprehension, the police started detaining people without notice or information. So already we have a panicked society, an ill-informed society, migrant workers, people who are already not knowing, and because of lack of literacy, lack of knowledge, there is a herd mentality. What should be the role of the police? I must say that in several areas, including my own, the police have been actually going around distributing food which is being volunteered by several right-thinking members of society. But on the other hand, there is a portion of the police that is detaining people. We have to look at that. We have to make it realistic. There are public health concerns. There are health concerns of those who are in jail. There are, and these need to be addressed in this lockdown period. It is not normal law and order of sending people into custody. What has to be looked at is we have to prevent people. The state has to ensure the life of its people. Article 21 is the most fundamental. So this is the most important. And let me read the last portion of this slide. The importance of legal representation at this stage cannot be overstated. To ensure grounds of arrest and FIR are supplied to the arrestee and his or her family, that there is material justifying the arrest, and that appropriate applications are filed in case of allegations of custodial violence or illegal actions of the police during interrogation. How do you secure that when lawyers are themselves remaining locked in, and because of social distancing and the lockdown, not able to interview, meet with their clients, see their clients, speak to their clients, advise their clients, be there after 24 hours when they are being produced in the magistrate's court, and the magistrate's courts are not there. And the question is, the sessions court, for example, in several parts of India, sessions courts are not functioning. Now let's look at Uttar Pradesh. In UP, just to give an idea, 11,000 inmates lodged in 71 jails have been ordered to be released. If we look at Madhya Pradesh, at Maharashtra, again another, the state has recommended 11,000 inmates to be released and making COVID-19 tests mandatory for all new ones. And this is what I just spoke about. Mumbai's Arthur Road Jail houses 3,231 inmates against a capacity of less than 1,000. How potentially dangerous, and what a time bomb. Has set up 20 isolation cells for sick prisoners. The high security Yerwada jail in Pune has 5,569 inmates and 18 kids born inside prison. About this some other time. What do you do, and how should a state deal with those who are born in prison? Does the state have a duty to look after those children, or should those children continue to be brought up in jail? Children who feel that seeing anything but a mouse is a strange creature, is an animal which they have never seen. Now more about Maharashtra. An example of measures taken by jail authorities within the prison complex for inmates. Maharashtra Prison Department officials are identifying buildings located near prisons that can be used to keep new inmates in a bid to prevent overcrowding of jails and threat of COVID-19 infection to other inmates. While I'm talking of this, I want to remind that in Delhi, if a new inmate is being sent, for 3 days he's being kept in isolation. In Kerala, he's being kept in isolation for 6 days. And similarly, COVID tests are being done at the time of release of such prisoners. Additional Director General Prisons and Correctional Services Sunil Ramanan said to accommodate new inmates and to avoid possibility of infection spreading inside the prison, buildings which are outside but located near the prisons are being identified across the state. With regard to Haryana and other states, the state has asked prison authorities to come up with a block-wise timetable relating to food and other services. We must appreciate Andhra Pradesh, Uttarakhand, Punjab, Ladakh that have identified vulnerable group of prisoners. Prisoners with respiratory diseases, prisoners with diabetes, prisoners with heart trouble, prisoners who have cancer or have a propensity of low immunity require special attention, and these states and their committees have been looking at such prisoners. In Rajasthan, Jharkhand and Kerala, attempt to decongest jails is being made. At the same time, and this slide may come little later, Rajasthan High Court at one time, when one of its court officers was found being COVID-19 positive, suspended proceedings. The same have gone to the Supreme Court. The Supreme Court has stated that, and also there is a practice that the caste or community of a person is noted against their name, that the Supreme Court has already issued directions that that can't be done. Now, coming in so far as the National Commission of Women is concerned, the National Commission of Women have been receiving complaints with regard to domestic violence. Domestic violence is on the increase, not only in India but internationally, and therefore, taking into account the condition of women in women's ward, they've asked for bails for women to be taken up at an urgent and priority basis. While we say that, the Delhi High Court has made directions, and so have some other high courts have made directions with regard to coming up of cases of domestic violence, and helpline has been set up. The UN Secretary General has urged governments to put women and girls at the center of COVID-19 recovery. Now, talking internationally, India's record is much better than those in other countries because India has learned from their experience. As we know that India got hit in March 2020, whereas several other countries of the Western world, and China, of course, starting with China, were hit much earlier, and therefore the cases of people dying in jails, suffering from coronavirus in jails, is far more rampant in various countries, and I'm showing you first the US. 73% of the inmates at an Ohio prison test positive for coronavirus. The large cluster of cases was found through mass testing of everyone at the Marion Correctional Center. Now, unfortunately in India, we do not have the kits for mass testing. So we do suffer a huge disadvantage as far as that is concerned. Now, Washington prisons, 300 inmates were released, and coronavirus continues to spread. In North Carolina, an inmate has died due to coronavirus. Now coming to Bangladesh as well as other countries, 10 doctors, the conditions with regard to jails, the conditions with number of doctors that are available for the jail and for prisons is completely low and is not realistic. The proportions and the numbers of inmates as compared to the number of doctors servicing them is extremely few and not proportional. Similarly, Ghana, there are 46 prisons with 15,000 inmates and only 2 doctors. So this, in the developing and underdeveloped world, the condition and overcrowding in the detention centers calls for bail. No one can run away from India. Most people can't even run away from their city or the place where they are lodged, or unless they are given access by police or court to allow them to go to their home states or homes. In such circumstances, unless the twin principles of will this man abscond, will this person tamper with the evidence, they can't even be tampering with evidence at this stage. So both those conditions can't be fulfilled. Therefore, it's best to give temporary bails, interim bails for 2 months across board, unless it's a case where someone's going to go and commit rampant murders, or there's going to be an apprehension of a huge risk to society. The law which has been laid down by Gurbakh Singh Sibhya in 1980 in Supreme Court, the law that has been laid in Siddharam Maitre, I think it's 2008 or 11 of Supreme Court, where Justice Dalveer Bhandare and Justice Radhakrishnan said so. So we have to look at that. Look at Pakistan. Look at the UK figures. Now a little more about the UK. The UK has put guidelines. Those guidelines are very clear, and they have said categorically that UK guidelines have said categorically that the courts, insofar as trials are concerned, trials will not be done. Criminal cases and major cases will be looked at. Most of it will be through audio and video recording. Now let's look at the Supreme Court, and this is of greater interest. On 13th March 2020, the Supreme Court restricted the entry of persons in the court premises. In an unprecedented move, litigants, media were barred from entry into the premises, and it was notified that no person except the lawyer required during arguments and oral submissions or to assist the arguing counsel would be allowed inside the courtroom. Of course, this worked with some difficulty for senior counsels, because we're used to having lots of people helping us, assisting us, and we could only in Supreme Court have the advocate on record with us, and we weren't allowed to have our paraphernalia of our colleagues, some of whom have our judgments, some of whom have our promptitude. They are giving us some prompts. So with that, but of course, difficult times lead to difficult solutions, and therefore we are facing this with a grin. Now on 16 March 2020, in the same suo motu petition number 1 of 2020, the Supreme Court then looked at, in court of its own motion by the Chief Justice and Justice Nageshwar Rao, gave directions of various nature to the prison authorities. These are to contain the coronavirus and are therefore welcome. By 22nd March 2020, the Supreme Court said only urgent matters will be heard by a bench of 2 judges through video conferencing. Before that, when it was hearing matters, it was dividing, say, 14 matters, 7 before, then cleaning the court, disinfecting the court, then 7 matters. And obviously, it was still putting at risk various personnel. So, in view of the special times and special needs, this is what the Supreme Court has devised. Only extremely urgent matters are being heard by the court. E-filing is being done, mentioning is done, and that's how the Supreme Court has been taking care of the matter. But let's look at the overall picture which Supreme Court has done, which is then on 23rd March 2020. It said, and these are extremely important, of course, while it gives protection, it does take away certain rights. So the protection, physical presence of prisoners before trial court is dispensed. No routine transfers of prisoners. Prison-specific readiness and response plans to be developed. Monitoring team to be there. Each state and oblique union territory to have a high part committee. The high part committee has then to see who can be released. The same thing has to be in line of Arnesh Kumar, so 7 years and below. And now we come to Arnesh Kumar. Most of you are familiar with Arnesh Kumar versus State of Bihar. It came as a breath of fresh air to my mind, because even though Supreme Court in D.K. Basu and Joginder have said that the power to arrest is one thing and doing an actual arrest is another, and has spoken about the liberty and about the freedom of the individual, particularly the under trial, the police have not been obeying it. Now, Arnesh Kumar set down guidelines how a police officer has to behave. It has to send a notice under 41A to the accused in case they feel that it may be required to be arrested, and first wait. So the guidelines as given under 11.6, 11.7, 11.8 may be looked at. Before I turn to the next slide, Arnesh Kumar, we hope, will be respected more than D.K. Basu and Joginder have been, and the courts have been in judgment after judgment emphasizing the importance of compliance with Arnesh Kumar to the police. Now, coming back to the Suomoto case, on 23rd March, it was felt, and again on 7th March and 13th April, the court said, you may release these people, but what's also required is safe passage for these people. Passage that they may be able to stay in their homes. Passage that they may be able to go to their homes. And it can't be an argument that how can we allow them to go to their homes? Thousands of people have been assisted in reaching the haven of their homes. Rather than be homeless, rather than be on the road, it is safer and better that these persons are in the sanctity of their homes, where the chance of spreading coronavirus or contracting coronavirus is much lesser. So the Supreme Court laid down these guidelines. Provide them temporary shelters or give them transportation. Allow them to have that transportation that they can reach their homes. Now, on 23rd March, the Supreme Court reiterated a word of caution, saying it's not that we are saying every case has to be released, but committee has to be set up and prisoners have to be released after looking into facts. If a person suffering from coronavirus, he should not be released during that time. If he, after the release, if he suffers, then before he is brought back, he should be given the requisite amount of quarantine. Transportation should be provided. The Supreme Court has furthered and furthered its commitment to trying to ensure that those under trials, those convicts who are in custody, are given safe passage and are given bails. There are several cases in Supreme Court where interim bails had been granted. Periods were expiring. In most of those cases, the courts have extended the interim bails. Some of them, the courts have said the person will surrender after 1 week of the lockdown being over. In other cases, the courts have said the person will surrender immediately after the lockdown is over. In other cases, the courts have given interim orders, which I believe will likely be extended till the lockdown is over. There is no reason that persons should go back to a crowded prison and be subject of custody. Now, another recent judgment which has hit the headlines is the editor of Republic TV, against whom several FIRs were lodged, and only on 24th April 2020, bench of Justice Chandrachud and Justice Shah were pleased to give him 3 weeks protection. This is how, although this was done under Article 32, but this is how Section 482 in similar cases can be brought into play. A novel fact while we are dealing with this subject is Delhi High Court Justice Bambani has said that you can actually ping your location, you can bring down your location on Google Maps and through video calls, and therefore you don't need to report to the police. So this is something interesting. Several judgments of the Delhi High Court along the lines of giving interim bails during this period, people who are ill, people whose parents have expired, people whose family members need protection, and the manner in which they will report to the police is novel and indeed an application of how the courts will look at this. This is a recent case, and in fact, subsequently after the Delhi High Court was not able to give interim protection because the person's father had died, saying that it's 800 kilometers and perhaps he may be under risk, is 7th April and 13th April Supreme Court judgment as an answer that you would have to provide them safe transportation. Also, the proof of the person's demise has can be verified by the state. State has now, Supreme Court has permitted the parties to file fresh petition for bail in the Delhi High Court, and on this notice has been issued and state nominal roll has been directed to be filed. Jammu and Kashmir problem is a complex problem, and in fact Navroz Sirwai has discussed it and has said that question of internet access at such a time should be something which should be taken up by the court on an urgent basis and looked at. And he then quotes Nirinde, which will come later, where he in fact further quotes, is this a republic or a monarchy? And he said, a republic if you preserve it like a republic. So we people have to be vigilant to preserve the rights of our people. The criminal justice system has to ensure how now on the lighter side are certain aspects of the Rajasthan High Court and a person appearing in a dress which was unwarranted, which was a banyan. Now here we come to Bini Dholani, the Maharashtra High Court, beautiful judgment where persons had to go to Assam. The court said, you will ensure, and it was a letter written to the Chief Justice, treated as a writ petition, and the court has said, look at it and let him get safe passage to go to Guwahati if there has been the death of his father. A Mumbai Sessions Court, I'm pleased to say, has granted interim bail to former Infrastructure, Leasing and Finance Services Vice Chairman Hari Sankaran and Managing Director of ILNFS Ramesh Baba on the ground that of their low immunity in view of COVID-19. Rana Kapoor also sought bails on ground of low immunity, but the court has not accepted it. Now, I am skipping the UK. It was a very detailed thing about which I have already talked. In the US, as I've said, the court is going to be hearing arguments, it said, in matters in May, and trials are postponed, but other hearings by sitting remotely are being done. Now, silver lining. The silver lining is that street crimes have come down. Are we happy about that? Yes, we are happy, but street crimes should come down with education, with good policing, and not by just remaining locked down. Definition of 482 inherent power. I'm not going to read all these. I just come straight away to some of the parent judgments on this. R.P. Kapoor versus State of Punjab, 1960 Supreme Court, which was a case of under cheating, and the court said, and this is significant, it can be quashed if the case being dealt with belongs to, is against an accused is an abuse of process, and quashing would meet the ends of justice. It appears there is a legal bar against the institution of a case. For example, a want of sanction. Say a public servant and there is no sanction. Say under Scheduled Caste, Scheduled Tribe Act, and it should be an offence within public view. It's not within public view. Say it's a case where on the face of it, shows it's a civil case, it's not a criminal offence. Then in those cases, the quashing can be done. The last, where there is no legal evidence. This in Madhav Rao Scindia, I think it was 1998 Supreme Court. The Supreme Court said that if the chances of conviction are bleak, the evidence is pathetic, it's almost non-existent, then such proceedings can be quashed under 482. State of Haryana versus Bhajan Lal. This virtually has become the fund norm under 482. Whenever we draft a petition, we try and make sure that it comes within any of these 6-7 parameters laid down in State of Haryana versus Bhajan Lal. So these are, and I'm not going to read it out, some of them I've just read when I read R.P. Kapoor where the allegations in the FIR are so absurd, where it's done for vindictive purposes or for malified reasons, where the FIR and other materials do not disclose a cognizable offense. So these are, and prima facie you look at the FIR. Now while I say this, I will later come to Dipendranath Padi, which is a Supreme Court judgment which says that materials which may be beyond the charge sheet or beyond the FIR can be looked at by the higher courts if they are unblemished, if the quality of that material is sterling quality. There we are. 2005 1 SCC 568. I've already told you what it says in principle, and there was a previous view in Satish Mehra versus Delhi administration, which was a case of purported incest, and there the court said that the material was not sufficient and quashed the proceedings at the inception. So Justice Anand's bench, and therefore this expanded on the same concept in Devendranath Padi, which is a great judgment in case we are talking about 482 Quashing 226, where you are looking at the FIR or charge sheet and looking at. Now, why is it so important? Why is emergent relief so important? Emergent relief is so important because, and why is interim protection so important? Because there is great ignominy in being an accused where a person is being falsely implicated. And therefore, while the rights of a complainant are important, the rights of an accused are also equally important. It is for this reason that one of the fulcrums of criminal jurisprudence and rule of law to avoid a person being falsely implicated is that at the very threshold the court can quash proceedings. Now, the next citation that I wanted to show was Avnish Bajaj, because there are several judgments on it, where a director of a company, as you know, in criminal law, there is no vicarious liability. So a person has to be having a mens rea. And if we are looking at mens rea under the penal code or under statutes which require mens rea, and there is no vicarious liability, then persons who may have been implicated, you would remember the case of Avnish Bajaj, where a video clip was being circulated of a school of Delhi of 2 children, and the question was, would you implicate the managing director even if he had nothing to do with it, and if he was only, if the website was only an intermediary under the IT Act. Then you would also look at Anita Hada and other judgments under 138 and G. Sagar Suri, cases where people are just being brought in without any good reason. Now, I'm not going to speak largely on Gyan Singh, Narinder Singh, and Parbhat Bhai, because those are judgments where, going back to the earlier slides, those are judgments where, in case of settlement, question is of non-compoundable offences, would the courts quash in 482? What the courts have said is, if it's right at the inception, if it is really a contract or a matrimonial case, we'll quash. If it's a very serious case, we may not quash. And I'll go on to the next slide and then go back to the earlier one. Parvat Bhai Ahir, This was a case where a person has extorted and cheated and forged, allegedly. So the sections were 384, 468, 471. And then the question that arose was there was settlement. The courts did not quash. Very recently, bench of Justice Chandrachud said that such cases, quashing should not be done where it appears that there was some history of the accused, some past history. Now I'm going to skip the rest of Parbat Bhai, but I just wanted to come to Prashant Bharti. Prashant Bharti and Raju are two judgments of Supreme Court among many others, which are judgments where there's quashing in cases of false accusation of rape. And one of the aspects which Supreme Court says in that, and I like that, Justice Dalveer Bhandare, it cannot be lost sight of that rape causes the greatest distress and humiliation to the victim, but at the same time, false allegations of rape can cause equal distress, humiliation, and damage to the accused as well. The accused must also be protected against the possibility of false accusation, particularly where a large number of accused are involved. So, having said that, the court felt that there are cases where on the face of it, if one looks at it in depth, those are cases where quashing should be done. And in many of those cases, the courts have given interim relief so that proceedings in trial do not go on. In this same context is Preeti Gupta, where in 498A, several persons were made accused. Married sisters living miles away, having nothing to do, were married before. The court said, you can't just rope in people like this. This is what it said in G. Sagar Suri and Anita Hada with context of 138. This is Preeti Gupta in context of 498. Is Prashant Bharti in the context of rape, several other cases. This case, State of Telangana versus Habib, is also interesting, where the court distinguished stay of investigation as stay of other proceedings, and the court said normally it will not stay investigation. We can't part with this subject because Supreme Court then discussed Hema Mishra. As you would know, UP and Uttarakhand did not have anticipatory bail. So by a judgment in which one of the authors of the judgment was Justice Sikri, in Hema Mishra, the Supreme Court said that it would give protection from arrest in cases where there was no provision for bail. Now, having said all this, what's the time? No, finish it. Having said all this, what I want to say is that because after Lalita Kumari, if a person's accused of a cognizable offense, FIR has to be registered. Very often the police will arrest even if there is yet not a charge sheet or a closure report, and frequently investigation may be flawed. Therefore, 482 is one tool which comes to the assistance of a person who may be falsely accused and falsely implicated. This tragedy teaches us that less is more. I hope we learn all this. Now, this article by Mr. Navroz Sirvai, which is recent, I think it came yesterday or day before, is something which needs to be looked. Benjamin Franklin, a US founding father, was asked by a lady, "Doctor, what have we got, a republic or a monarchy?" Sirvai recounted that Franklin replied, a republic if you can keep it. Let's try and keep this republic. I'm very happy to note that more and more the Delhi High Court has said it will now be taking up more matters, and we have to give greater access to justice. The same way that medical doctors are working round the clock in emergency cases, even at risk to themselves, we are, while taking all precautions, have to open the doors of justice, whether through video conferencing or through other means, more and more, so that access to justice is not denied. Thank you, everyone. Are there any questions?
Thank you, ma'am. There are two questions which have come up.
Okay.
The chat, we have shared it with you. If you can just read and answer those
I'll
two
just look at it. Can you read it out? Okay, the first question is, lockdown is not defined explicitly anywhere. So what laws central government is exercising, and does that mean our fundamental rights are not enforceable under this lockdown? To my mind, of course it's enforceable. Fundamental rights have not been abandoned. We are, this is not ADM Jabalpur. We are talking of a time when fundamental rights are available, habeas corpus writs are available. We need more access. We need the courts to take up more hearings. We need more matters to be coming in court. And of course, what the courts can do is not dismiss any matters. If it finds interim relief is to be given, it may give it. Otherwise, the matters can be adjourned beyond lockdown, because ultimately oral hearing is part of hearing. So that's what's important. According to me, the lockdown does not, even though it's not defined, and there's a very good parody about it, what a lockdown means. Does it mean I can go out? Does it mean I can't go out? Does it mean I need to look after the old people and go out? Does it mean I can't go and look after old people? But having said it, the last word is this, that even though there is a lockdown, the rights to the legal system, both under criminal law and urgent relief under civil law, should not be denied to any person. We are not in an emergency. And even in an emergency, there are some rights which are integral, which cannot be denied. What's the second question? The second question is, if quashing proceedings are being filed in High Court as alleged, accused being falsely implicated, IO is not stopping its proceedings and have declared accused as PO. Now in such situation, what should be done? As I was speaking, to my mind, this is, and there should be a general direction to this also by the commissioners of police in all the states. This is not the stage where PO proceedings should be initiated. This 82-83 proceedings should not be initiated. Summoning should not happen. The police should be doing their policing duties, their law and order duties, several other duties. All this can wait. So if this is what the court said, this is what has been done, there should be recourse available to approach the court. Now, one of the issues is, although Jagdish Nautiyal and some other judgments say that you can ask for interim relief while 82-83 proceedings are being initiated, but there are two judgments of Supreme Court which tell one to be wary about this. That is Lavesh, once 82-83 are over. So, but according to me, a clock should be turned back. These are not cases These are not times when 82, 83 should be invoked. These are not, and the High Court should look at these cases and see if it deserves to be stayed. There are one or two other cases, questions. Can a FIR be quashed where the daughter-in-law has leveled allegations of rape against the father-in-law? Settlement has been arrived at in mediation. This is a vexed question, because the Supreme Court has said that normally in case of rape, quashing should not be done. But the Supreme Court has also said that in matrimonial proceedings, quashing or settlement can be acted upon. I think that's the tenor of Gyan and Narinder. So my view would be that of course quashing can be done, because ultimately these are matrimonial proceedings, even though allegations of rape are made. And to my mind, Supreme Court may have to rule on it, or some High Court may have to rule on it and hold that these are essentially matrimonial proceedings, because there is a difference between rape allegations or allegations of unnatural sex in matrimonial proceedings, and those allegations against a pure stranger which are of a different genesis. So according to me, a distinction can be drawn among both of those, and they can be looked at. So may I, we have a lot more questions. May I just answer 3 and close the session? I don't want to exceed my time. So, are the courts obliged to grant an interim bail to the accused with respect to offence under NDPS, considering the present situation? Is there any precedent? So no, the courts are not obliged. This is the first thing. Courts are not obliged, because most NDPS cases would be 10 years punishment and above, and therefore the courts are not obliged. Even on 7 years and below, they are not obliged. But there is a precedent of interim bail being granted by Delhi High Court in an NDPS case. I don't have it offhand just now, but there is a precedent where interim bail for 45 days or some period has been granted in some exigency of a person having child or parent having health issues or medical issues. So that precedent is there, and I don't remember the precedent. Then there is a question: if just before lockdown on bail was reserved to be announced, but due to lockdown the same could not be announced, what remedy is available? To my mind, the Supreme Court, and coming to Karthik Dangi was a case where yes. So in this case which I've just discussed, if before the lockdown on bail order was reserved to be announced, to my mind, sometime the district courts will have to start functioning. We cannot abdicate functions. So they may have to start functioning from their premises. They may have to start functioning by disinfecting the whole premises. They may have to function from a 2-room premises so that there is no central air conditioning. There isn't central air conditioning in most district courts anyway. But it should function in such a manner that the courts cannot not function. And particularly where bail orders are reserved, according to me, a court has to take permission from Registrar General to hold court and to pronounce in those cases. Otherwise, there would be no option but to go to the High Court under 482 and seek directions that the court should be directed to give bail. In fact,